Have you filed a defense in a county court claim, and now you're wondering what happens next? Well, this is one of those stages where the answer is usually not very exciting. After a defense has been filed, there's often a period of waiting. No courtroom drama, no judge knocking on the door, and no final decision overnight. The next stage often involves waiting to see whether the claimant files something called a reply to the defense. Now, despite the name, a reply isn't a second claim. It's simply another document that gives the claimant an opportunity to respond to the points raised in the defense. Interestingly, not every case has one. In many claims, no reply is filed at all, and the case simply carries on to the next stage. So, if nothing arrives through the post or online, that doesn't automatically mean anything unusual has happened. If a reply is filed, it usually comments on the defense. It might agree with certain facts, disagree with others, clarify something that was said earlier, or explain why parts of the defense are disputed. It can be viewed as two different versions of the same story being placed before the court. It doesn't decide the case. It doesn't mean the defense has failed. And it certainly doesn't mean the claimant has won. It's simply another document that becomes part of the court file. Some replies are only a page or two long. Others are much more detailed. Some repeat arguments that have already appeared in the particulars of claim, while others focus on answering specific points made in the defense. Every case can look a little different. Here's a simple example. Imagine Adam, an electrician wearing his bright yellow hard hat, carries out work for Bob. Adam says Bob hasn't paid the final invoice. Bob files a defense explaining why payment is disputed. Adam then files a reply explaining why he disagrees with parts of Bob's defense. At that point, nobody has won the case. The court simply has another piece of the overall picture before moving on to the next stage. One of the biggest misunderstandings is thinking that a reply somehow defeats the defense. It doesn't. Another misunderstanding is thinking that filing a defense automatically defeats the claim. That doesn't happen either. These documents generally help define which facts and issues remain in dispute as the case progresses. Once the reply stage has finished, or if no reply is filed, the case usually moves towards the court's case management process. Depending on the type of claim, that commonly involves allocation questionnaires, directions, or other procedural steps that help prepare the case for later stages. And then, there may be another wait. Court proceedings often move in stages, with periods where very little seems to happen. Even during those quieter periods, the case is generally continuing through the normal court process. So, after a defense has been filed, the next stage often involves waiting to see whether a reply to the defense is filed. If one is filed, it usually responds to the points raised in the defense. If no reply is filed, the case commonly continues to its next procedural stage anyway. It's simply another step in the journey through the civil court process. And in litigation, sometimes the most dramatic event of the week is hearing the letterbox flap.